Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm Nipasa Pradhan, and I welcome you to another interesting webinar that we're going to have today. But before we dive into the topic and I introduce you to our guest, I have this very important disclaimer. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, we are streaming live on YouTube, LinkedIn, and Facebook. Thank you so much for joining us. And let me tell you that this is going to be an AMA session, Ask Me Anything session. So, wherever you are, you can drop your comments, your questions in the comments, and we will be very happy to take them up. So, it is going to be a very crucial topic for many of you, navigating the complex world of US immigration. And today we are going to be discussing on the topic facing an RFE, an NOID, or an NOIR, and what would be your next move. So these terms, are very important, and we will have none other than our guest for today, special guest Justin Rivera, attorney and expert immigration attorney, specializing in employment-based immigration, and definitely a staunch defender in cases involving H-1B visa, RFEs, and NOIDs. Welcome, Justin. Thank you so much for joining us today.
Thank you so much for having me again. I hope you're having a good Friday.
I am, yes, very excited for this day and also the weekend that's coming up. So, Justin, what can folks out there expect from this episode today? We are going to talk about RFEs, NOIDs, and NOIRs.
Well, obviously, if you've had any experience with any of these types of government issues, they're never fun. But just kind of going maybe into a bit of an overview of what each one of these are, what their impact is, what are the typical things that you see for each of these categories, and then maybe kind of a general idea of how to respond in certain situations or what's typically expected from the government. And I mean, it's gonna range based on what type of visa you're filing under and where you are in the immigration process. I mean, obviously the RFE is a request for evidence that is going to be submitted. That's going to be issued when you're applying for an actual benefit, whereas notice of intent to deny is notice from the government basically saying that the benefit you've applied from they believe should be denied, which is
Mhm.
a more difficult situation typically than an RFE. You're usually given less time to respond. And then lastly is the NOIR, which is the notice of intent to revoke. And that's for issues where you've actually already been granted a benefit and the government has come back and claimed either there's new evidence that shows that you no longer qualify or that they
Mhm.
made an error in approving the benefit in the first place. So each of them are unique. They carry with them their own issues and difficulties. And I'm happy to discuss them as someone who's unfortunately had a whole lot of experience with each of them.
Definitely, we are going to dive into each one of these topics, and it is an AMA session. Once again, let me remind you, folks, ask me anything. So, under the topic or close to the topic, you can definitely ask anything, and Justin is here to give you expert advice and also answer it to your questions. So, since
Yeah.
it is, yes, Justin, I'm excited, and we have our first question already, and this is from Online School on YouTube asking, Madam, who apply DS 160 form, employer or employee?
So the DS 160 form is completed when you are applying for a visa abroad at the consulate or embassy, which means that the entity applying for it is going to be the individual who fills out the DS 160. So that's going to be the employee. Or the individual, depending on the visa that's being applied for. So the DS 160 again does need to be filled out by, let's say it's an H1B, it'll be the employee that fills it out. Just on the subject of DS 160s, you do need to fill one out for each party that is applying for a visa. So that means, if it's you, your spouse, both of you need to apply, not just one. You're going to need to complete the DS 160, submit the DS 160, and carry a copy of the completion page. It's a printout that's at the end of the DS 160. You're going to carry a copy of that with you to
Mhm.
your interview as well.
Oh, okay, great. Thank you so much for taking that up for online school. And Justin, before we move ahead, could you also tell us more about this? I mean, like, if it is a person, can one have an RFE and an NOID and an NOIR at the same time, or that's not possible at all?
No, no. So what should only happen is there should only be one issue coming from the
One.
government at one particular time. They should never stack on top of one another. Also,
Okay.
the notice of intent to revoke, that NOIR, that is only coming after the case has subsequently been approved. So the NOIRs are usually, in my experience, unfortunately, I've seen NOIRs come out of site visits. So, for example, maybe there's an H-1B site visit where the employee is not working where they're supposed to be working, and then
Mhm.
USCIS issues, as a result, a notice of intent to revoke, claiming that the H-1B has been violated. I've seen that happen. I've also seen situations where they come back to revoke, saying that they approved the case in error for some reason, maybe claiming that
Okay.
the individual qualified for the H-1B, and then they're now subsequently saying they don't because of new evidence. So that's usually what you're going to see for an NOIR. The RFE, I mean, I think people love to talk about probabilities for RFEs. We all want to be very statistic. It's really hard for me to be honest about that. I have found in my experience that RFE rates are service center centric, if that makes any sense.
Okay.
So what that means is there's various service centers that cases can be filed at.
Mhm.
Usually it's based on where the petitioner is located. If it's
Mhm.
a quota case, then it's going to be based on what's on the receipt, the selection notice. But in my experience, the service center can kind of dictate the RFE rate. Oddly enough, I don't know if that's a training issue or what, but just speaking from personal experience, I do sometimes feel like there'll be phases where it's like, oh, Texas is just, for whatever reason, they're issuing the highest number of RFEs, or maybe it's California or Vermont, and it
Okay.
just seems to go in waves. So I really don't think that it's easy to put like an exact number on the probability of an RFE.
Mhm.
I will definitely say, between administrations, the Trump administration and the Biden administration, I think there's less RFEs coming in from the
Okay.
Biden administration. At the same time, that does not change the fact that I have absolutely seen nonsensical RFEs. And what I mean by that is it's just, something is being questioned by the government that it's almost ludicrous, because, it's like the petition itself has already stated these facts out ad
Mhm.
nauseum, and then you're basically just issuing an RFE to issue an RFE. I've definitely seen that. But yeah, so that's really that for RFEs. And then notice of intent to denies, you don't see as much. At least I don't typically see them as much. Um,
Okay.
but the notice of intent to denies are tough because you only have like 33 days to respond, usually 30 to 33 days to respond, and the government is coming to you basically saying, hey, we are on the verge of denying your benefit. This is not a 50-50. This is not a, hey, we might need a little bit more. This is, we have looked at the evidence, or we have found additional evidence, and we are telling you this is going to get denied unless you can provide XYZ. So yeah, the noids are tough. I think, generally speaking, for anyone, if you get a notice of intent to deny, I mean, within like 4 days of receipt, you need to have spoken with your attorney and come up with a strategy on how to respond.
Mhm.
The RFE, you have a lot more leeway. There's way more time to respond, and typically your attorneys are going to have seen the issues come up before. The
Okay.
NOIDs, the notice of intent to denies, are pretty specific to the individual. So
Okay.
you do kind of have less time to strategize about how you're going to respond. So yeah, I would say notice of intent to denies, like, worry about them. Whereas with an
Worry.
with an RFE,
Correct.
yeah, it's an RFE, but understand that they're not completely uncommon.
Absolutely. All they are doing is requesting for more evidence, and once you can prove, and there are more chances for it to be approved.
Right.
Right, Justin? Thank you
Yes.
so much for the detailed explanation. I'm sure folks out there have a better picture now about RFEs, NOIDs, and NOIRs.
Mhm.
And we definitely have so many questions, so we should quickly take up this one from Rakesh. He's saying, I have two questions. The first is, what is the probability of getting RFE for the experience letter not being on company letterhead? I do plan to go for premium processing. And question 2 is, what is the probability that my manager gets contacted by USCIS to verify the letter? Manager has provided his email and phone number on the signed letter. Also, this employment did not happen in the US and it was in my home country. Manager is based out of my home country.
Yeah, I mean, obviously, I think you can tier evidence, and at the top of that tier, you're gonna when you're requesting anything from an organization, you want the information to be provided on company letterhead. That's always the best course of action. Now, unfortunately, that's not always the case. So yeah, I would definitely say if you're providing an experience letter that's not on company letterhead, you are increasing your probability of receiving a request for evidence. Is that impossible that it won't get by? No, it's possible. Um, but at the same time, I would definitely say you would prefer it to be on letterhead. So what's the probability of your employer being contacted by USCIS? I don't know. I mean, maybe I can't give you an exact number, but I mean, it's possible that they're going to verify information. I think they're more likely to want to verify information because you didn't actually put the letter on letterhead, which they
Yeah.
love for whatever reason. So yeah, I mean, I think that it's not the strongest evidence. You're probably going to get an RFE, would be my guess. But and you, I don't think that they're probably. I think it's unlikely that they're going to be contacting your manager. Now, at the same time, it's not impossible that they would, and I don't think you would really care if they did, right? I mean, they would just be speaking to the information that they've already affirmed in the letter in the first place. So sorry if that's not as helpful as you wanted it to be, but that's kind of all I have on that subject.
Yes, that's true. But I think also it would depend on the officer's mood on that day. I mean, if he's having a bad day, he would probably go call also. Who
Right.
knows?
That's true. That's true.
All right, Justin, thank you so much for taking that up. Rakesh, thank you for your question. Thank you for participating. And if you have more questions, we're here for some more time. Moving on now, let's go to Ritu. Question on YouTube. My husband received RFE and I wanted to know what would be some really strong evidence for proof of marriage to prevent from receiving another RFE. I have a child with him and I submitted car insurance, bank statements, marriage certificate, birth certificates, and 30 photos of us. Please help.
I mean, a mortgage is always good if you have that. It's always good to show that you have agreed to home ownership together. Evidence of cohabitation is always strong. I What's not really provided in here is how long you two have been married. The duration of the marriage, I think, it can help. Obviously, if the marriage has been longer. But I mean, I think that's a strong start. If the bank statements are joint, car insurance is okay. Birth certificate, benefits maybe. Are both of you on the same health insurance, life insurance? Thing is, are you named as beneficiaries in any of each other's
Mhm.
benefits? I think those are all things that you could provide in addition to what you've already given. Um, I think that would be great. So I would start there, kind of looking through what benefits you guys have. Obviously, the mortgage would be great if there's evidence of that as well. It looks like you guys have provided a lot of pictures already. I know sometimes attorneys look into getting attestations from individuals that speak to the marriage. You could maybe look into getting some of those attestations as well to kind of
Mhm.
buttress it along with the additional proof. But yeah, I would look through. I would do that, and then obviously, if you don't have an attorney at this point, I would definitely hire one who has experience in this kind of response and get their input on it and get them to kind of take care of it for you. But yeah, I think that's kind of all I would provide.
All right. Thank you so much for taking that up. And Ritu, thank you for your questions. I hope you got your answers. But my question is, I wonder why is your marriage questioned? If you have that, also maybe Justin could give a better answer.
No,
And
I mean, look, this kind of speaks to what I was talking about at the top of requests for evidence. I mean, yes, I have seen less of them under the Biden administration, but the nonsensical ones have not gone away. And what I mean by that is, and this is a theory that's hypothesized with me and some of my colleagues, so this isn't gospel, but I do feel sometimes when I get RFEs and I'm working on cases, I do feel sometimes that there's almost like uh, a numerical level that an officer has to reach in issuing RFEs. Because, and I'm not saying that that's true, so don't quote me on it, but I get confused because I'm literally wondering, how does case X get a request for evidence and case Y gets an approval and case Y is weaker? Like it doesn't make
Oh,
sense. It just depends on who that officer is that's doing the response. And then to me, I sometimes feel like maybe it's just their turn to issue an RFE. So yeah, I mean, it can turn on that or a lot of things. We don't have the details, the specific details of this person's case. Maybe the marriage is very new.
mhm.
I'm not sure, but that could be a factor as well.
Yes, could be. Thank you, Ritu, once again for your question. And thank you so much, Justin, for taking that up and explaining with so much patience.
Sure.
Now let's move on to this one on YouTube again from Varun. I received an NOIR for my EB3 petition, but I have obtained a new job offer from a different employer in the same field, and I'd like to transfer my petition to the new employer. Can I respond to the NOIR by withdrawing the original petition and filing a new one with the new employer? Or do I need to appeal the NOIR decision first?
So I think this is a little too specific for me to give a general answer to. I don't, what is in the NOIR matters here. I think the content of the notice of intent to revoke is very important in making a determination on how you're going to be responding. Is
Mhm.
there an accusation of fraud or misrepresentation contained? And if so, then I would definitely say you need to respond to make sure that that there is no finding of fraud. So I would say I would need to look at the content of that. And so I'm going to kind of leave that one alone, Varun, but please feel free to send me an email with that info, with that, if you want to get into the more specific details of that. And then I'd be more than willing to take a look. And maybe if needed, we could set up a consultation. But yeah, I think that would take a lot of time to dive into, to be honest. And I think in the interest of time, let's just move on, and I'll be happy to answer that on email.
Absolutely. And you have Justin's information right there on the screen, friends, and you can note it down. His number is 844-592-7336, and you can email Justin at support@wasden.law and go visit wasden.law to get to know more about Justin and Wasden immigration litigation. Thank you so much, Justin. And now let's move on to this next one. We have from Rakesh. He just says, thanks for the information given. Thank you, Rakesh, for joining us. And
You're very welcome. That was
moving
my
on.
favorite question so far.
Supriya, we have this one on YouTube as well. I received a NOID for my L1A application stating that my company doesn't meet the required number of employees. However, we've recently hired more staff. So, can I update my application with this new information and respond to the NOID to avoid denial? Do let me know if anything else should be done.
So I have bad news for you. Um, your L1A has to qualify at the time you apply. And what that means is at the time you submit the case to USCIS, you need to show that you qualify in a managerial or executive capacity. If you're getting a notice of intent to deny based on the number of individuals you manage not qualifying as managerial, then your answer can't necessarily be, I have more people that I manage now. Because USCIS is going to very easily sidestep that by saying, we don't care. At the time you applied, you said you managed these 3 people. And now you're saying you manage 6. We don't care. At the time you applied is what counts. Therefore, you don't qualify. Um, so that it's not as simplistic as just saying now I manage more employees. I think what you'd have to get into detail about is, are the people you manage professionals? Are they degreed professionals? Do they
Mhm.
manage people? Do you manage a function? And what I mean by that is, are you responsible for an integral part of your organization? And can you show that in your management of that function that you handle the upper level while the day-to-day stuff flows down to your subordinates? Because I would definitely say that there's no threshold for employees to say someone is managerial. What I mean by that is there's no handbook that the officer looks at that says 5 people managed, you get an L1A. You can be a manager and manage one person. You have to show that you manage that one person, and you're probably going to have to argue that you're more of a functional manager than a people manager, but you're still able to do that. And I've definitely successfully done that before. And I've gotten L1A manager approvals for people who manage as little as 3 employees, 2 employees even. But it's about showing what is the responsibility that you have within that unit. Do you have the ability to hire and fire? Do you delegate work responsibilities? Are you responsible for a budget? Do you make line item decisions? Where are you within the organizational hierarchy itself? Are you somebody who's under an assistant manager, or are you at a higher level where the 2 people that are your reports, maybe they're your only reports, but you guys are responsible for, hypothetically, a $4 million budget for your organization? You have to show that value. And USCIS loves numbers. They love numbers. So if you can qualify your value, either through like units or monetary value, budgets, anything like that, it goes a long way. So yeah, I definitely think don't go with just saying, now I manage more people. What you got to do is work with the hand you were dealt with originally and try to show that the position that you held at the time qualifies for the L1A.
Very well put, Justin. And thank you so much for taking that up. Supriya, I hope you got what to do and all the best. You can do this. Let's go on. Now we have Deepa on YouTube asking, what are the chances of first time visa stamping approval after being associated with Integra during initial OPT? I received RFE for my first H1B stating my association with Integra and stated
Right.
I would need consular processing. However, my company lawyer responded to the RFE and it got approved with status change. That's it.
Okay, so I think what I'm saying, what I'm getting from this is they told you to consular process your H. You filed a change of status. You got an RFE. You responded to the RFE, and the case got approved. That's great. So you were able to transition to H1B. Fantastic. But you haven't gone for visa stamping yet. Yeah, I'd be concerned. I would be concerned about the employment with Integra. I mean, Integra clearly has that blacklisted company status that I've seen. I think that it's completely possible that you could see issues at the consulate. I think even if you get past the consulate, it's possible that you could see an issue at the port of entry when you come in for inspection. So I definitely think that carries with it its own risk. I know inevitably you're going to have to go for stamping, and I've heard, I haven't experienced it myself, obviously, but I have heard that it's kind of a crapshoot. There are people who have gone and not had issues going for visa stamping, and then there's people who've gone and gotten a 221G, basically, which is a visa refusal. Usually they'll ask for more evidence or more information, but that 221G can make you sit for a long time. So I would definitely, I would be concerned. I would but I would not travel if you could avoid it, but I understand that that's not possible. I mean, inevitably people are going to want to go home. So yeah, I would just say be ready. Be ready if you are asked the questions about it. I would definitely bring a copy. If your RFE was related to Integra employment, you need a copy of that RFE response. I would say even bring it with you to the visa appointment, or if not, at least review it and go through it. Remember that RFE response is part of your record. So any information that was disclosed in that response needs to line up with what you provide during your visa interview. So yeah, I think the big part is uniformity, ensuring that the information that you provide is the same information that has been provided throughout the entirety of the process.
All right, Deepa, thank you so much for your question. By the way, Justin, how important or within how many days should you get your first visa stamping done in
I mean,
case of a
it's not.
situation?
It's not a. It's you just have to do it within the validity period of the H-1B petition of the approved H-1B. So obviously, if your H-1 is approved for 3 years, it starts on 10/1 and maybe goes to 9/30/2027. You got to get it
Mhm.
done during that time, or you should get it done during that time.
All right. All right. Thank you so much. Thank you, Justin, for that detailed explanation. And Deepa, thank you for your question. I hope you got your answer. Now let's move on. This one is also on YouTube from Dinesh. I submitted my RFE response for STEM approval to USCIS on June 10th, and the portal shows that it has been received. How long can I expect to wait for an update on the status of my application? Additionally, if my application is denied, what options do I have available to me?
So clearly, based on your timeline, this is a regular processing filing, meaning you did not opt for premium processing. So you're in regular processing, you're subject to whatever timeline that is. You can check timelines online and see how long it's taking for visas to process based on where the application is, which service center that it's been submitted to. I think if I remember right from my experience, STEM OPT, you're probably going to Texas, if I remember right. But yeah, I mean, you can check there and see. I June 10th on your response. That's a long time. You've been waiting, and I'm pretty sure you've probably exceeded the extension period you get for filing.
Mhm.
I mean, if I were you at this point, I would probably just look into upgrading to premium processing because my assumption is if you're in the U.S., you're hanging out right now without work authorization. So I would maybe consider just upgrading to premium and getting a decision. If your application's denied, what options do you have? STEM OPT, if your STEM OPT is denied, you need to leave. I mean, you can go abroad and try and apply for a new visa abroad, but don't just hang out in the United States with no status. Typically, STEM OPT RFEs are, I would say, generally approvable. The only ones that I've encountered recently that have become problematic are these ones for um, scam employers. I can't say it any other way. Basically, there's
Mhm.
a list of companies that seems to have made its way to USCIS, who they essentially would approach F1 students,
Okay.
who needed an OPT employer and give them OPT employment in return for a sum of money, a fee. And that fee seems to have vacillated between 3,000 and 2,000, and maybe even in some cases $1,000. And so the individual would pay the employer and they would get the letter. The letter stops their OPT unemployment clock, which can't
Mhm.
exceed 90 days. So it stopped that clock and it gives them time to find another employer. Now, it looks like a lot of kids had to utilize this during COVID because they were having trouble finding employers during that time frame.
Yes.
It's coming back to bite them. I mean, I've seen it come up now for STEM OPT for people. I've seen it come up for people trying to enter the U.S. at the port of entry.
Mhm.
I mean, really, to me, if it's a STEM OPT RFE and you didn't have an issue with an employer and you were able to furbish the documents that they wanted, I would just upgrade to premium and get your approval. I don't see a reason for you to wait. I mean, if you had the only things they're really going to be asking about is, prove you were employed with the company, prove you didn't, violate the 90 days of OPT unemployment. If you were
Mhm.
able to do that, I think you should just go ahead and get your case approved. Now, if that's not the case, and the issue was that, they were asking about, I don't want to use the specific names of the companies, but if they were asking about company A or B, and your employment with them, and you were not able to furbish anything, and you're probably going to get denied. And the big issue there becomes: is there a finding of fraud? Because a finding of fraud leads to inadmissibility, and that is incredibly problematic. So
Yeah.
yeah, that's a whole other issue. But just generally speaking, if you're going to be if you think that the case you submitted was strong and you think it should be approved, go ahead and upgrade to premium. Just get your decision.
Thank you so much, Justin. I'm sure this was very helpful for Dinesh. Dinesh, thank you so much for your question and thank you for participating. So I think it is kind of time to take a short break now. And we still have so many questions on the way. I'm very happy to see Ishwar and Lali. Please stay with us. We will take up your question, but quickly after the short break. Yes, friends, today we are discussing on if you are facing an RFE, an NOID, or an NOIR, what should your next move be? And we have none other than expert immigration attorney Justin Rivera helping us navigate through these questions you have for us. It's an Ask Me Anything session, so keep commenting. We will be very happy to take them right after this short break. Only on Immigration and Jobs Talk Show with me, Nipasa Pradhan.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408 335 6444 or mail us at nipa@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. This is Nipasa Pradhan, your host for today. And this is the second half of this webinar we are having on this discussion facing an RFE, an NOID, or an NOIR. What's your next move? And we have none other than our very special guest for today. We have attorney Justin Rivera, an expert immigration attorney who specializes in employment based immigration and really helping us navigate today on this topic. We have taken up so many questions from the audience already. It's an Ask Me Anything session. So feel free to drop your questions in the comments, friends. We'll be very happy to take them up. And thank you, Justin. So far, so good. Very enthusiastically taking up all these questions. It's really lovely to get your answers. All right, then without further ado, let's move on and go ahead with our next question. We have this is from Ishwar on YouTube. Okay, before we take up your question, Ishwar, we have this question on WhatsApp asking, my I-140 petition received a NOIR citing inconsistencies in my education credentials. I have submitted each and every document that I had. Now, what further should be done?
If you've submitted every piece of available evidence that you have, and you submitted every piece of evidence being requested by the service, then all you can do at this point is basically argue that standing on the evidence that has been provided, your case should be approved. You're going to need an attorney to basically make that argument on your behalf, and maybe go through point by point and refute any inconsistencies that USCIS is claiming exists. Just to clarify the record, USCIS is not they're not perfect, meaning that they make mistakes themselves. It is totally possible that in reviewing your case, they didn't review it with the detail it needed, and the inconsistencies that they're alleging exist may not be to the exact parameters that they're alleging. Further, they could just be flat out wrong. So yeah, I mean, when you're in that circumstance, you just have to stand on your evidence that you've presented and make an argument that USCIS needs to approve your case based on what you've already submitted. There's really not much more you can do if you've already given them everything you have available.
Mm-hmm. Thank you so much for that, Justin. Thank you for taking it up. And thank you also for your question. Now let's move on to Ishwar. This is on YouTube. Ishwar, thank you so much for being so patient. I have taken your name several times and finally taking your question now. I am on H-1B and I have valid visa until next year, but my I-94 is expiring on 30th of September 2024. They gave me till the expiry date of my passport when I went to stamping last year. Do we
Mhm.
need to go out of the country for I-94 extension? For your information, I renewed my passport 2 months ago.
Yeah, super easy. Just pop out and pop back in. Go to Mexico or Canada, stay for 2 or 3 days, and then re-enter. You can either go by land border or air. Air is safer for me in terms of getting an I-94, an electronic I-94, because they're pretty consistent about updating their records. Land borders aren't as consistent about updating their records, but if you do pop out and pop back in and your I-94 has not been updated, you could go to a CBP deferred inspection office. And when you go to that deferred inspection office, you can show your travel history and the documents that you presented. So that'll be your most recent passport, which has been renewed and is going to give you that full extension. And that's going to allow them to extend your I-94. But yeah, you do need to travel.
Okay. Okay. So I mean, the stamping on the passport is also going to be great value, right?
Yeah, absolutely. Yeah, so you're not going to have an issue because you still have that valid passport. I mean, yeah. So yeah, I don't think you'll have any issues. It's
Great.
it's very common, unfortunately. You
Okay.
can you can talk to CBP about it, but they have to have committed an error in order for them to correct it. And in this circumstance, it's not an error. When they admit you, they are permitted to admit you to the end date on your passport if it's less than what your validity period is.
Okay. Okay. Thank you, Justin, for taking that up for Ishwar, and thank you, Ishwar, for your question. Let's take this next one. This is from Lally, also on YouTube. I am a startup founder on an O1 visa, and my company is undergoing a merger. Now I can ensure that my visa status is not impacted by the change in company structure. And what documents should I prepare to demonstrate the continued validity of my O1 petition?
So I think all of this turns on whether or not the company, the company that's coming in is a successor in interest. What I mean by that is it sounds like they are if it's a merger, but you have to look at the language that's being provided in the contracts and make sure that the company is assuming all of the immigration responsibilities of the other organization. So what I mean by that is when the company merges and becomes A, or A is eating up B. Is A taking on all of the immigration obligations that were held by B? If that is the case, then they're going to be what's called a successor in interest. And a successor in interest is going to assume those liabilities, which means you shouldn't need to do anything until you go to extend your O1. And then at the time you extend the O1, you just need to provide documents showing, hey, this company is the successor in interest. And as a
Mhm.
result, when the merger occurred, I continued the employment allotted to the conditions of my O1 merely for this employer because they assumed the responsibilities of my immigration status. So that's really what you have to look at is this a successor in interest issue? If this is not a successor in interest issue, then it's problematic because at that point that means you're going to need to file a new O1 with this company as the
Mhm.
employer. I would assume that is rare for you in a situation where you're on an O1. My assumption would be that they want to have you as an employee. They want you as part of the deal,
Mhm.
and they'll be doing what they need to do to make sure that that's taken care of. So yeah, I would just say make sure that that they qualify as successor in interest, and as long as they do, you're fine. O's, you don't really have a whole lot to worry about with successor in interest typically. The people who kind of get the short end of the stick are the L's because that there's the foreign company and the U.S. company, and it just kind of depends. But yeah, for you, that's what I would go with is just make sure that the company is going to qualify as a successor in interest. If you don't know, talk to your immigration attorney.
Okay. All the best, Lally, and I'm sure it's going to be okay for you. And in case you need to consult an immigration attorney, and if you want to contact attorney Justin Rivera himself, why not, note down his details, which are scrolling down on the screen, and feel free to contact him for sure. All right, Justin, before we move on, I also wanted to know uh, how can anyone out there, avoid having an NOID in future immigration filings?
I mean, so the RFE and the NOID. So the RFE, how do I avoid an RFE? Sometimes it's unavoidable because you're just in a circumstance where you've presented as much evidence as you have, as much evidence as
Mhm.
possible. And for whatever reason, you get an RFE, on the
Mhm.
occupation, beneficiary qualifications. I don't know. I just had a colleague of mine get like a 4-issue RFE on a case that they knew was a straight on approval. And for whatever reason, that officer picked apart the evidence, gives him a 4-issue RFE. But the short answer is the easiest way is always to present the strongest evidence that you have up front. I know that there are attorneys who don't want to quote unquote empty the chamber. And what that means is like, I don't want to hand over everything I need to because if we get an RFE, then we got to have more evidence to provide. I've never agreed with that. I think you put the strongest foot forward and you have all the
Yes.
evidence up front. So that way that your probability of approval is as high as it can possibly be. It is totally possible when you get an RFE to say, look, I gave you everything. And if you need maybe one or two more items, like here, but everything
Mhm.
else, you pull those bullet points that USCIS loves to put about evidence to provide and you pick it apart. You go through and you say, oh, you wanted this, I gave it to you. You wanted this, I gave it to you. So all you're asking for is this one thing. Okay, maybe I don't have that one thing, but I've got the other 7 things that you asked for on the list. And, this
Mhm.
is a preponderance of the evidence standard. So clearly, if all of these things I've been able to provide to you should be able to get me approved versus the one thing that you think I don't have gets you denied. So that would be my opinion for the RFE. The NOID is hard because honestly, notice of intent to denies. I mean, you've either got a kill shot in your case, meaning there's something on there that the officer is so confident about that they're going to
Mhm.
deny you, that they're basically giving you notice because they have to before they deny the case,
Mhm.
or they acquired information that they legally have to give you as part of your record because it is adverse to you. So that's where you get into issues like site visits, or investigations, that the government has maybe committed against your employer, and then they are kind of putting that accusation onto your case.
Mhm.
And that's totally possible. I've definitely seen that happen. So there's not really as much you can do, to prevent a NOID. I mean, if it's a situation where, I saw someone's case recently where, it just sucked. I mean, they got a NOID, on their I-485 because their very first H-1B employer was indicted for, visa fraud. And
Okay.
basically, they said, because your very first H-1B employer was indicted for visa fraud, we believe that your H-1B was fraudulent, which means you procured that benefit by fraud, and you are not
Yes.
eligible to adjust status. I mean, what could that person have done to prevent that from happening to them? They didn't know at the time they joined that employer that 5 years
Mhm.
later that employer was going to be investigated for fraud.
Hard luck.
There's right. They're not clairvoyant. There's nothing they could do to avoid that issue. So yeah, I mean, for the Noids, it's not often the employee's fault. It's more so an issue with the employer. The
Mhm.
other side of that coin, unfortunately, though, is if you're the employee. I've talked about this on other, chats, and I cannot reiterate this enough. If you're an H-1B employee, you need to be working where you said you're going to be working in your labor condition application. And I cannot say that any more sternly. I am so frustrated with what I see as either just people who don't care or don't know that just because their employer tells them they can work at home doesn't mean they need to have their home address listed on the labor condition application. Now, is it technically okay if you live in the same what's called metropolitan statistical area as the work address? Yes, that is okay. But do you want to even open yourself up to that issue in the first place? I'm sorry I'm on my high horse here, but I keep seeing it over and over, and it just makes me so angry because it's so easy to just add an address to an LCA, file an amendment if you're letting your employee work from home who used to be working fully in the office and you're letting them
Mhm.
hybrid, and just get it on file with USCIS. Avoid issues with a site visit, avoid issues when they go to adjust status in the future, avoid issues maybe when you go to file an extension. Because
You're correct.
there's just so much evidence that you can present that if USCIS really pays enough attention to go through, they can figure out if somebody's been working somewhere that wasn't covered on the LCA. And
Mhm.
it's such an easy win for them. It's so easy for them to sit there and say, "Oh, well, you were supposed to be working in Houston, Texas, but we noticed you're living in Delaware, and you're working from home in Delaware. So how is it that you're following the conditions of your H-1B?" And it's just file the amendment if you're letting them work from home, or if you're moving them to another project somewhere else, file an amendment. They're not, and I know it's a pain to have to go through that process, but I think it's much better to do that than it is to, deal with a notice of intent to revoke down the line, or maybe a
So
notice of intent
true.
to deny when you deal with, having to extend or whatever.
So true, so true. Folks, I hope you stop putting yourself into trouble. And if you have doubts, or even if not, it's always best to consult an expert. So go consult an immigration attorney, and it could be Justin Rivera himself. You can take down his information. It's scrolling down on the screen. And quickly, we will move on to our next question. But before we take up these questions, I have this question, which is from Shokat on WhatsApp. Thank you, Shokat, for your question. It says, I got multiple H-1B filing NOID notice from USCIS. Anyone here got same, or what is the best way to respond to them? Or drop H-1B is the best way?
That's that's interesting. I don't know if maybe this individual meant to say they got multiple notice of intent to revokes, because multiple notice of intent to denies means that they have multiple pending H-1Bs, which is
Okay.
a little interesting. I think that, like I said earlier, the NOIDs, they're typically more unique and less templated than a request for evidence. So I would say you need to look at the language that's contained within the NOID before you make a decision about how you want to respond. If you're getting multiple NOIDs, that means to me you've applied with multiple H-1B employers, maybe for a change of employers, and sounds like you're getting hit on the same issue. Maybe you're failing to maintain status, or they're accusing you of committing fraud or misrepresentation on your previous H1. I'm not sure. I would need to see the specifics of the actual NOID before I made that decision. I will definitely say if you're getting multiple NOIDs, then I don't think the issue's at the employer unless it's with the same employer. So sorry, if you want, you could try to drop an email to me, maybe with a copy of the notice of intent to deny. And I could take a look at it and see if maybe we could set you up for a consultation or something, but I would need to see it before I could really give you more information.
Thank you so much, Justin. And Shaukat, you should definitely go contact Justin. You can call him on this number, 844-592-7336, and mail him at support@wasden.law. Once again, thank you. And I have another one. This is on my email. I just received it from John. And John is saying, I was stopped at the US border because I had a full box of my business inventory in that box. They told me I couldn't take it with me, so I had to drive 5 hours back to my home to drop it off. Drove back the next day, stopped and checked my car for a few hours, then then let me in the US. My question is, do I need to mention that on any of the forms when I am applying for green card through USC petitioner? Do I need a lawyer? Any advice?
Okay, so if you were refused entry, then that may be something that you need to disclose in the future. At the time you file the I-485, it may be something you need to disclose if you were refused entry. To be completely honest with you, I haven't looked at an I-485 in probably a week, so I don't remember the exact language that's in the forms. So it would be something I'd need to review, but I would say generally speaking, you likely need to disclose that if it qualifies as a refusal for entry. I think it's weird that they said that you couldn't come in because you had business inventory. That's odd. My guess is you were coming in on a visa that doesn't allow for work authorization, and they were claiming that it looked like you were coming in to work.
Mhm.
And then that's why, as a result, they refused you entry. But then at the same time, they subsequently allowed you to enter. So in my head, I'm going back and forth about whether or not that really does qualify as a refusal. I would
Mhm.
definitely talk to a lawyer about it, and definitely let the attorney handle your I-485. Don't file that on your own.
Okay. Thank you so much, Justin, for taking that up for John. And John, thank you once again for your question. And moving on, I think we should quickly take up a few more questions because time is running and
Yeah, we're
we have
actually pretty
Pranav.
close. Yeah, to running out of time here.
Yeah. I received RFE in the mail yesterday. They require proof of income from my sponsor. I have two questions. Do we need to resubmit the I-864 form or just send the documents regarding proof of income? And the second question is, we have not filed our taxes yet. Would it be okay to send just the W-2 or should we file our taxes first, then send the tax return documents?
How have you not filed your taxes yet?
That's going to be trouble. Sounds like
I,
trouble to me, at least.
we're really far past that timeline. I'm guessing you guys got extensions. Yeah, wow. I don't think you should have to resubmit the I-864 unless there were errors in it. If there were errors contained in it, then I would resubmit it with corrections made. Send the evidence that they're asking for specifically in the RFE response. File your taxes, and if they're asking for that, get that done and send that in as well. Yeah, that's really all I have. Just follow the request that's in the RFE. They're probably not going to ask for you to resubmit the I-864 unless you have to make changes to the document.
Okay. Thank you, Justin, for taking that up. Crazy, but Pranav, I hope you come out of that situation quickly.
I'm amazed because with me, I file my taxes, and if I'm like $2 off, I have a letter from the government, in a matter of weeks saying that I did something wrong and owe them money. And these people are almost in
Yes, I
October.
wouldn't be
Okay,
able to
anyway.
sleep, I'm sure. Like, I would be
Well,
anxious all the time. I haven't paid my taxes.
okay, I will tell you, at my old job, I had somebody, he was a younger kid. He was a legal assistant, a paralegal. Paid his taxes like 10 days late, like submitted them 10 days late, and then got upset because it took so long for him to get a refund. And I was like, you're lucky you even got a refund in the first place. But anyway, that's neither here nor there. Yeah, I think we have time for maybe one more question.
We have, yes. Let's take this Rish V. I'm currently out of US for visa stamping. As the process is taking longer than anticipated, my company is growing increasingly concerned. I'm worried that this delay might make me lose my job. To be prepared for any potential outcome, I'd like to know if I lose my job while I'm abroad, can I still transfer my H-1B visa to a new employer if I find one? And what is the timeline for this process? Does the H-1B unemployment clock start if I'm outside the US?
Okay, so these are great questions and all turn on a bevy of caveats. Um, First off, is this your first H-1B stamp that you're going for? If this is your first H-1B stamp, have you spent any time in the United States already in H-1B? If you have been, well, yeah, I guess it could depend. So if you've spent either 1 day on H-1B in the US or you've received your H-1B visa stamp, you are now cap exempt on your filings moving forward. You have been counted against the cap. As a result, you are going to be able to move employers. So kind of let me posit this scenario for you. You were in last year's quota. You got selected. Your case was approved. You started working on H-1B on 10/1. You've been working on H for the past year, and then you went outside the country and went for visa stamping. For whatever reason, you're stamping. I'm guessing you got a 221G, so your case is on hold, and you're worried about losing your job. Could you transfer your H-1B to another employer if you were let go from your job? Yes, you do have the ability because you are cap exempt. The other side of that coin is if you are outside the United States, you get your H-1B visa stamp, and then maybe haven't entered the country yet, but you get let go by your employer. Can you change employers to another employer? Yes, because you have that visa stamp. It's an either or for being counted against the cap. You have either spent at least 1 day in the US in H-1B status, or you have received an H-1B visa stamp. Does the H-1B employment clock start if I'm outside the US? I have great news for everybody. The US doesn't really care what you're doing outside the US in terms of work. So what I mean by that is you don't ever have to worry about time outside the US being spent towards the H-1B or an L1 max out date. That is not relevant to them. If you are outside the US, you are not
Mhm.
bound by the conditions of your visa. So you don't have 60 days to find a new employer. You have as long as you need to find a new employer in the event that you're moving employers. So just generally speaking, you're saying that the process is taking longer than what you thought it would take. I would ask, why is that? Did you receive a 221G? Have you received an email from the consulate requesting additional information? Have you provided that information? If you have provided that information, have you sent follow-ups requesting a status update? In unique situations where you're dealing with this type of scenario, it could be possible that you need to utilize LegalNet. LegalNet is a way for you to reach out to an entity that's going to basically answer a question of law. If the issue is about something specific to the law in your case, LegalNet will look into it. It's possible that they can contact the consulate to ask them to resolve the issue and get your case approved. This turns on what the issue is, though. So what I mean by that is, why did your case get a 221G and what is holding it up? So yeah, I mean, it's going to be unique, obviously, to your circumstance or situation. I would say if you've been waiting for a while, probably around 60 days, maybe think about reaching out to our office to schedule a consultation or at least an initial email so we can get some more information and see if that could be something we could help with.
Thank you so much, Justin, for taking that up, and Rishvi for your question as well. And absolutely, Justin, I think that's a wrap for today's insightful discussion. And I really want to say thank you, Justin, for sharing your invaluable expertise with us and helping us navigate through all these questions we have from the audience. Thank you so much, everyone, for your questions. And Justin, before we really leave this session and end the session, do you have an end note for all folks out there who participated and anything about the topic as well?
No, I mean, thank you for your time. I know everyone's time is valuable, so thank you for choosing to spend it with us, and give me an opportunity to speak to you about some of these issues. I definitely think my takeaway from the questions today is, when you're at a point where you get a request for evidence or a notice of intent to revoke or a notice of intent to deny, if you have not already utilized an attorney, please go utilize an attorney. Okay. Like, I understand people want to save money and people think, if I watch enough YouTube videos and read enough articles, I can do this myself. I get it. Trust me. I have also tried to fix my electronics without contacting an electrician. But it doesn't always work. And you do need to understand that when you've reached this point where you're at an RFE or a notice of intent to deny, if you have not invoked that attorney, the first thing the attorney is going to have to do is come in and fix what may have not been done correctly in the first place. And then they're going to have to address the issues. So I would really just say, get an attorney at this point. Don't respond to this stuff on your own. If you work with an employer and you have a request for evidence, for your H-1B, and the employer says, "Oh, we do these all the time. We'll take care of them." You don't have an attorney, maybe say, "Hey, let me go do a consult with an attorney first and see what they have to say before we make the decision to respond on our own." Remember that your immigration, ultimately it's on you what happens with your immigration. So yeah, that's my soapbox issue for today. Is just make sure that you guys are working with attorneys when you get to this point. I would recommend working with an attorney the entire time, but I understand that's not always possible. And that's it. Just other than that, thank you all for your time and hope everyone has a great weekend.
Thank you so much, Justin. And if you really do not mind, we just have one last question from our audience. I don't want to keep him waiting for another session. And if you can quickly answer this, maybe in brief, would be great, from Love of God, asking, when I went for the interview, they said my I-129 is revoked. Neither I nor my employer get any notification, and still my status showing approved. What does it mean? Kindly help.
That's interesting. So you went for an interview and they're alleging that your I-129 was revoked, but your status is still showing approved. So I'm guessing this is your USCIS case status, which you're looking up with your you're looking up with your receipt number, and it's still showing your case is approved. So if in order for them to revoke an I-129, you should have received a notice of intent to revoke, because you're entitled to that and you're entitled to an opportunity to respond. So that's definitely interesting if that's the case. I would say the thought process here is to maybe reach out to the consulate and see if they can give you some clarification as to how they saw your I-129 was revoked, and share with them a copy of the page, the USCIS case status page, showing that your case is still listed as approved. Maybe if your case was filed in consular processing and the officer is feeling, or the service center is feeling very generous, you can email the premium unit and explain that you were told your case was revoked, but you never received a revocation notice. And again, provide a copy of the USCIS case status showing that the case was approved. That would be where I would start at.
Thank you so much for taking that up. And thank you so much, Justin, for being so patient and for extending the time a little bit as well.
Yeah, sorry. I have another call coming in. That's why I was looking over here. Sorry about that.
No worries, but thank you. You're a great sport. And thank you, Justin, for doing this today. I think we can let you go now.
All
Thank
right.
you. And for folks out there, please feel free to contact Attorney Justin Rivera himself. And you can call him on this number. You can note down these contact details. Call him at 844-592-7336. You can even email him. It would be best to mail him at support@wasden.law. And definitely go check out www.wasden.law to get to know more about Wasden immigration litigation and also Justin Rivera himself. Also, friends, please follow Wasden Immigration Litigation on LinkedIn for more immigration updates. And you can also contact me. We also sponsor H1B, H4, and anything with regard to immigration. Please feel free to contact me as well. You can call me on my number, 408-335-6444. This is also my WhatsApp number. You can also email me. My email address is nipa@highrightypeople.com, and visit us at www.highrightypeople.com to get to know more about us. And thank you so much. Also, if any one of you is interested in joining our shows as a guest, please email about yourself. Note down this email address, Rajni, Rajni, at highrightypeople.com. Thank you once again for joining us. And thank you, all you folks, for the lovely questions and for participating and for making this webinar a more interesting one with your questions. And once again, thank you so much, Attorney Justin Rivera, for your time and for your patience and for, patiently answering all these questions very nicely in details. Thank you. And friends, feel free to also subscribe to us. Please also hit the bell icon, because whenever we have discussions like these, you will be notified. And like, share, and subscribe to our channel for expert insights on immigration and employment. Until next time, then, stay informed and stay empowered. This is Nipasa Pradhan signing off from Immigration and Jobs Talk Show. Bye-bye.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us in the number 408-335-6444 or mail us at nipa@highrightypeople.com or visit our website www.highrightypeople.com.